Hi, everybody. Thank you guys for coming. This is a wonderful turnout. Wow, great. So I wanted to just start with just telling you a little bit about Laguna Legal and who is Laguna Legal. We are not attorneys. We're a bonded and certified legal document service. A lot of times people think that they need attorneys when they're dealing with legal documents, and that's not the case. So we're bonded and certified. We've been in business for 25 years, and during the past 25 years, we can help clients prepare legal documents. We can help them do court filings. We can help them with deeds and accommodations. And we're going to touch on some of that today. We help with probates. We help with all kinds of things that your clients need. So it's a great alternative to having to hire an expensive attorney unless you need one. Of course, we refer a lot to attorneys. We have a lot of attorneys that we're very close with and we work with on a regular basis. But we will only send clients to those attorneys if they really need an attorney. They don't always need an attorney, and sometimes people think that the attorney is the only option when they're starting. So we serve all of California and all courts. So we can help with filing documents throughout the state of California, not just in Orange County. If you have a client up in San Francisco, if you have a client in San Diego, we can help with filing any kind of court documents in any of these counties. And then we prepare deeds for properties, and we prepare those throughout the United States. So a lot of us have clients where the clients live in California and they have properties in California, but they also have a property in New York. They also have a property in Arizona. We can help prepare all the documents for your clients so that all of their needs are met with one spot, not just the California properties. Attorneys don't do that. They only deal with their territory. So we deal with throughout the United States. And we're also a direct electronic recording service. So that means that we directly from our office are able to record documents throughout the United States for any counties that accept electronic document recordings. There are still some counties that don't accept document recordings electronically, but most of them do, and more are coming on board now that COVID has happened. So we can record documents throughout the United States electronically. And okay, so now let's go through our slides. This is going to be important information that every realtor needs to know. So what we're going to be talking about today, we're going to be talking about accommodation recordings and why you should never have title or escrow record them for you. We're going to talk about reassessment, what factors can trigger a property tax reassessment. We're going to talk about how to avoid probate and understanding the different ways to hold title. We're going to talk about a new law that's on the that CAR is supporting. It's AB 717 and what changes are coming to revocable living trust education. And then we're also going to talk about LLCs versus corporations and what are the benefits. Accommodation recordings. Why you should never have title or escrow record them for you. So title, as you guys know, title and escrow deals mainly with sales of properties. So when you're buying or selling a property, your clients expect to get reassessed because it's a new purchase. So anytime there's a new purchase, there's going to be a grant deed, and that grant deed gets recorded, and there's a documentary transfer tax that's calculated, and that documentary transfer tax is what tells the assessor's office what the amount of what the reason was for the purchase, what the amount of the purchase was, and then they'll base their property tax assessment on the purchase price. So what we do when we do accommodations is we make sure that all your documents are coded in a way that they do not get reassessed. So sometimes we'll get calls from clients and they'll say, oh, we want to add a sibling to title, or we want to transfer, like I want to transfer to my sibling the property. And then what we do is we will make sure that we put the proper R&T codes, and the proper R&T codes are what keeps the assessor's office. It's like our communication with the assessor's office that lets them know why the property taxes should not be reassessed for this particular transfer. Sometimes we need to do multiple steps in order to make this happen. Sometimes it's impossible to make it happen. So we'll be very straightforward with your clients and with you if it's impossible. But there's always a way. We found that there's always a way. And the way that you do it is sometimes you'll do it in a multi-step process. So let's say if the brother, one sibling is transferring to the other sibling, if they were to take it from sibling A and transfer to sibling B, that's an automatic reassessment because it's from person to person. And so what we found works is that we'll add them on as joint tenants. So we'll have the two siblings be joint tenants on the property. Having someone added on as a joint tenant is not reassessable. And then we'll wait, but we can have the client sign both deeds at the same time so that let's say the brother is leaving the country and isn't able to sign in 60 days. We'll prepare both deeds. We'll have them sign both deeds and record and notarize them both. Step deed 1 would be from party A to party A and B as joint tenants. And then deed 2 would be from party A and B as joint tenants to party B as an individual. It doesn't guarantee avoiding reassessment, but it cuts it down by a very, very large margin. We have been doing this for 25 years and it works very well for our clients. When they do get reassessed, we are able to help them deal with the assessor's office to revert the assessment back to the previous number in a lot of the cases. So we also offer that service where we'll deal with the assessor's office to get it reverted. So that's about accommodation recordings. I'm going to stop at every slide and just see if you guys have questions on the slide rather than waiting till the end because I think that maybe you'll forget your questions. Does anyone have any questions about this before we move on?
So then how do you go through escrow? How do you tell escrow not to do that and then you just hire you to do it?
Yeah, we're doing we're talking about accommodation recordings, not purchases. If you're selling a property, you're going to use escrow, you're going to use generations escrow. But if you are not selling a property and let's say you just have clients that you want, ultimately our goal as realtors for all of you is to build rapport with your clients and to do a good job for them because they may not be the one selling their property, but their cousin may be, their neighbor may be. And so by doing a service to them to help your clients, you're actually helping yourselves because they're going to end up remembering you and they're going to go back to their neighbors and recommend you as their real estate agent. So if you're dealing with escrow and you're doing and your clients are doing a purchase, of course you deal with escrow. This is just for accommodations. It used to be that every realtor that I talked to, they would tell me that they go to their title company because title used to draft these documents and they used to record them. So you would go to title and title would say, oh yeah, we'll do a deed for you, and they'll draft it and they'll record it. And why they have stopped doing it is because they are getting complaints from property taxes that are being reassessed. They're doing a favor and then it becomes more of a headache. How many of you have dealt with that? Where you're doing a favor for a client and then it becomes more of a headache because they are like calling and complaining about the reassessment happening. That's why title and escrow have decided they're not doing accommodations anymore. That was very great for our business. Honestly, our business tripled when that happened. So all of a sudden now all the escrow and title companies are referring their clients to Laguna Legal to do these accommodations. So hopefully you guys will do the same, and we promise we'll do a good job for your clients when you do.
It costs to do that. Do an accommodation.
We charge the question is, now I know. How much does it cost to do an accommodation recording? We charge $600 to prepare, and it's the preparation, the in-house notary, the recording fees, and the electronic recording of the document. So for $600, they're going to save so much money on property tax reassessment.
That's amazing.
Yeah.
That's a great question.
Hi, Victoria.
Have you done in Laguna Woods where not to add a spouse or whatever joint tenancy, right?
We deal a lot with Laguna Woods.
Avoid the GRF fee, the $7,500 GRF fee?
I don't know. I don't think you can avoid that. I don't think you can avoid that. And then a lot of times with our Laguna Woods has two types of ownership. So they have deeds, for those of you who don't know, they have deeds, and then they have co-op certificates. So what you're talking about is the co-op certificates. There's nothing we can do with that. But for the deeds, it's the same exact situation. It has nothing to do with the co-op certificates. Yeah. Any other questions? Okay, good. So what can trigger property tax reassessment? Well, transferring property from one individual to another can trigger reassessment because obviously that is coded as a sale as far as the assessor's office is concerned. And not clarifying like-for-like transfers. So an example of a like-for-like transfer is what I talked about, where you're like, the person that's still staying on title is already on title, so that's a like-for-like transfer. Another like-for-like transfer would be, for instance, if somebody wanted to transfer their property to an LLC and they weren't identifying, because a lot of times they'll do it, they'll just put, okay, John Doe is transferring to the whatever ABC LLC, and they won't code it properly, so they're not letting the assessor know that John Doe and ABC LLC are the same people, so it's like for like. That is very important when you're doing these deeds, and that's why people call us all the time and they're like, $600, oh my God, that's so much money to do a deed. And it's really not that much money when you think about the knowledge that's going into, you're having someone that has knowledge helping you and your clients. So, and then lack of R&T codes, which is what tells the assessor why a transfer is exempt from reassessment. And then like we talked about before, there's that multi-step process, and that multi-step process makes each transfer like for like. And that's what we specialize in. So we're able to get to the finish line, like we're starting here and our goal is to get here, but maybe in order to start here and get here, we need to go through a couple extra steps to get there, and that's what we do. There are additional, obviously it's $600 per deed that we prepare. So it's not a one-time price of $600 for 3 deeds, but that is, we go through all of that with the client. And of course, if they still want us to do it as just one deed, we'll do it as just one deed. It just, this will kind of educate them as we go through the process. And then, the biggest drawback and the biggest reason why property taxes get reassessed is you're not hiring someone that has the knowledge. When you hire someone that has the knowledge and the experience, we've dealt with the assessor's office. We know what they're looking for. We know how to code the documents. So we will make sure to do that for your clients. Any questions on this slide?
Does a trust trigger the reassessment?
What was the question?
Does a trust trigger a reassessment? And no, it doesn't, but again, it can because it needs to be coded properly. So a lot of times what will happen is someone will transfer from themselves to their trust, but it's not coded, it doesn't have the correct coding, and that does cause a reassessment. And then we'd have to go through the process to get it reversed. Hi.
Question. So the like-for-like transfers, the first case is the owner stays on title, and then they add a second person to the title. That's called like-for-like.
Yeah. So the question is like-for-like. She's questioning like-for-like transfers and how they work. And like-for-like transfers would be that's one example of a like-for-like transfer. It's not the only example. Would be if person A adds person B together as joint tenants, and then person B then comes off later, as opposed to going straight from person A to person B. That's definite not like for like, because A and B are not the same. But since A is on both transfers, then it's like for like, and since B is on both transfers, it's again like for like. So that's a way of avoiding. Another example of like-for-like transfers would be like, for instance, if a husband, and we've seen this happen, so a husband and a wife are on title together and they want to transfer it to his LLC. So it's husband's LLC, he's the only member of the LLC. If they go from husband and wife and they transfer it to his LLC, it will get reassessed because that is not like for like. Like for like, under that definition would have to be the exact owners of the LLC or the exact owners of the transfer. So what we would do in that circumstance is we would do 2 deeds. We would do an interspousal transfer deed as deed 1, taking wife off title so that it's just husband's name, and then deed 2 would be from husband to his LLC. Or we would do another option, which is since we're a legal office, that's the beauty of working with us, we could also change the LLC documents to have husband and wife both be the members of the LLC, and then that way it is like for like. So we look at all of that before we record documents. Any other questions?
Accommodator? 1031 accommodator?
Are we a 1031 accommodator? And no, we're not. No, we're not. So we deal with a lot of 1031 companies, and they do send us a lot of business where we end up doing like LLCs for them, or we've had clients that have closed, they sell a property and they call us quickly and they're like, close our LLC. And then their accommodator is like, what did you do? You can't close that LLC. You need to purchase your new property in the name of the LLC. So in those cases, we're able to reopen the LLC with the same name quickly and get that done. So we get a lot of calls like that.
Did you say there are some timelines that you have to wait a certain period of time for each? Yeah.
Yes, so the question is about the timelines, and yes, it is a good idea to follow the timelines. It's not a have to, but it is like you want transfer A to go through the assessor's office and be evaluated before you throw on transfer B, because obviously that's going to be a red flag. We're trying to avoid red flags.
What would that look like?
Usually 60 days. Yeah, usually that's a 60-day process to go through the reassessment. Some clients choose to wait a year to do it because they just don't want to take any chances. The longer the period, the better the chances that it's not going to get reassessed. Okay. So how to avoid probate and understanding the different ways to hold title. So I've already had like a lot of questions about probate even before we started from clients. So I know that this is a hot topic for you guys as real estate agents. I'm going to go through the slides, but I want to say that we do assist with uncontested probates at our office. We can help with preparing all of the documents when your clients are in a probate. And the probate process for us, I mean, it's the same probate process. It's about a year to go from beginning to end of probate. But we're able to get the property, get the order for probate usually within 90 days. And 90 days will allow you as agents to be able to list the property and sell it for your clients. So we've definitely dealt with that a lot. And the only time that we don't get involved with probate is if the clients call us or agents call us and they say that they have family members that are fighting or they have issues like within the family. We're a legal document service, so we're not attorneys. That's where we would refer them to an attorney. Our fees are $500 a month. We charge flat fees to go through legal processes, probate, divorce, anything like that. So when we're dealing with those kinds of numbers from our end, we don't need the drama. We're just there to get the paperwork done. So we are, when we're having family members fighting and squabbling, we'll send them to an attorney because attorneys get paid hourly and they will, be happy to take those clients. For the clients that we take, we want them to be an uncontested, all family members are in agreement, and then they're willing to sign waivers and let one person be in charge. And then that one person will be the person that will be the executor of the estate or the administrator of the estate, depending on if there's a will or not. And then the best way to avoid probate, as all of you know, is to set up a living trust, and then not just set up the living trust, but title the properties in the name of the living trust. A lot of times we'll have clients that will set up a living trust, but they forget to do the deed or they forget to record the deed. That's the beauty of having our office do it, is we'll set up the living trust and we will also record the deed, because that's what we do. A lot of attorneys will set up the living trust and they'll just give the clients the deeds and have them record it, and then they end up not recording them. So if the property is in a living trust, that avoids probate. If the property if you have a living trust set up, but you don't put the property in the name of the trust, there is a condensed version of probate called a Hegstead petition. We do help with that as well, and we can help go through the system and get that done for your clients. To get it put into the trust so that it can be sold in accordance with the trust. That's what a Hegstead petition is. It's something that tells the court will let them know that it's a trust. And then married couples should never hold property. Okay, a lot of times people think that joint tenants is the way to go. Joint tenancy is not the way to go when holding property. Community property with right of survivorship is the best tax benefit for your clients. When spouse A passes away, the property transfers to spouse B, and they also get a step up in basis, which is the reason why a lot of people get living trusts, is because of the step up in basis that their beneficiaries get. That's available to spouses when they are holding title as community property with right of survivorship. And then adding children to title, we get a lot of calls from clients that will ask us to add their children to title because they want to avoid probate and they don't want to do a living trust. But they're actually doing a disservice to their children when they add them to title as joint tenants, because when the person that added the child to probate passes away, they end up the child inherits the property, but they don't get the step up in basis. And for those of you who don't know what a step up in basis is, a step up in basis is like, let's say the parents purchased the property for $100,000. So now the value of at the assessor's office is $100,000. And let's say that at the time, 50 years later, dad adds the child to the property as a joint tenant. And now the value at that time is $1.2 million. When the parent passes away and the child inherits the property, they do not get the $1.2 million value. They get the same value that the parent purchased the property for, which is the $100,000. And what that means is that when the property is sold, they have to pay capital gains from the $100,000 to the $1.2 million. Capital gains is about 30% in taxes. So they're going to end up having to pay $300,000, $400,000 in taxes, which will then make them not sell their property in most cases, which is not good for you guys as real estate agents, because you obviously want to help them sell the property. So getting the living trust is the way to go for that reason. And then a lot of people call us for transfer on death deeds, and that falls under the same category. It's not a good idea. There are no tax advantages to it. All it is just a beneficiary being listed on your deed, but there's no benefit to that. Any questions about this before we move on? Okay. There are lots of, oh, sorry, was there a question? Hi, Victoria.
So the transfer and death deed, when there's multiple beneficiaries, you recommend not doing it?
We recommend doing a living trust. Honestly, like we have people call us all the time. We do transfer on death deeds. We always work for our clients. So if they call and they insist and they've done their research and it's what they want to do, we will do it for them. But we recommend getting a living trust because the beneficiaries are going to get the best tax break. And then these are just some additional benefits of setting up a living trust that a lot of people don't know. So there's a step up in basis. There's the personal tax exemption. There's the married deduction, charitable deduction, and then special rules for married couples. So just to kind of give you an example on that, in 2017 when the law changed, it was 11.2 million. It's gone up. I think it's 12.2992 million now. It changes every year, but whatever it was, 11.2 million. For a married couple, they get a combination, 11.2 million times 2. So it'll be $22.4 million, which is exempt, which can pass to their beneficiaries without any taxes having to be paid by the beneficiaries. So definitely a living trust is the way to go. And our office deals only with revocable living trusts, We get calls all the time for irrevocable living trusts, for asset protection. There are other ways to do asset protection. We don't do irrevocable living trusts at our office because they're very expensive. There needs to be an attorney involved throughout the process. There has to be tax filings every year. So it's kind of like it takes on its own entity and you lose control of your asset. So we recommend usually putting properties in an LLC or a corporation as a way to avoid, just for asset protection purposes. Any questions on this? Oh, yes, hi.
It seems to me I read something about the current administration wanting to eliminate stepped-up basis. Do you know anything about that?
The question is whether the current administration is wanting to eliminate stepped up in basis. I've heard what you've heard. We don't know, and we'll see what happens. You know? Yeah. Yeah, it would be terrible if that happens.
So just to clarify, the child would get the property at 1.2 million with a step-up basis, and then they would pay taxes if they sold it for 1.5. They would pay 300,000 in taxes.
Yeah. So So the question is, if the child inherits the property at 1.2 million, they do get the step-up in basis, so they don't have to. But it depends on how quickly they sell the property. Because if they sell the property quickly, we could probably get, and you guys could probably get an appraiser to say that that was the value at time of death. But if they hold, because it's based on the appraisal at the time of death. So, but if they hold the property, let's say for 5 more years before they sell it, and then the value goes from 1.2 million to 1.5 million, then they would have to pay capital gains on the $300,000 gain. But if it's their primary residence, then they get also the exemptions that are available under that. So there are other exemptions. I mean, it's always good to talk to a CPA about all of that. Okay. Oh, yes. Hi, Ed.
The trust, the living trust, the day we create the living trust, is that the value of the property or when we assess the value of the property?
The question is, when does the value of the property get calculated? It gets calculated on the date of death. So not when you set up the living trust. I mean, I hope everyone in this room or under this awning has a living trust, because it's very, very important for everybody here to have a living trust. I hope that you learn the importance of it, because if you have one, then you'll be able to understand it better for your clients as well. But the value isn't on the date that you set up the living trust. The value is on the date of death. Yeah. And then, sorry, Victoria.
You do all my clients. I love this company.
I love you.
Regarding Medicare and Medi-Cal reimbursement, if you do have your property in a living trust, does that still negate it, reimbursement?
It's not. So the question is about Medi-Cal and Medicare and whether it's exempt. Like you're allowed. So under Medi-Cal and Medicare, you're allowed to have a primary residence that they're not going to make you sell and take away from you. But there is a possibility that you might have to, when the property sells, that you have to reimburse the state. We don't really get into that too much, but we get a lot of calls from people that think that the state's going to take away their primary residence because they're on Medicaid or Medi-Cal, and that's not the case. They will allow them to have a primary residence. They're not going to take it away.
When they pass, does it stop the heirs from inheriting proceeds?
No, it'll never stop them from inheriting proceeds, but they might have to pay back some of the money that the parent received. Yeah. So a lot of times we'll get calls to have it transferred to the children for that reason. Like they have to outweigh, obviously your clients each have individual situations and they have to outweigh what's their benefit. Like everything I'm saying is just general information, but they can meet with their CPA or with their attorney and and kind of like go through what's best for them. And then, okay, so AB 717 is a revocable living trust education. It's a bill that CAR is trying to pass. I have done a little bit of my own research into it. I don't know how I feel about it exactly. I feel like it's a little bit like a Prop 19 where it was masked as one thing, but it's actually something else. But that's just my opinion. But the part that got my attention when I heard it, because I was at one of the I was at Long Beach Broker Preview, and they were talking about revocable living trust education. So apparently this is a bill that they've been trying to pass for a long time, and it wasn't getting passed. So they added this little element to it, which is revocable living trust education, that there are so many homeowners that don't know about. So I'm gonna just read it to you because I don't wanna look up backwards. So I'm just gonna read it really quick. Some homeowners, particularly from low and moderate income communities, are unaware of the benefits of revocable living trusts for the transfer of real property to heirs upon the death of the owner. Many low and moderate income households do not have access to legal advice, and in comparison to higher income families, are less likely to engage in estate planning for their heirs. Without a revocable living trust, households must then generally utilize the costly and time-intensive court probate process. Expansion of education opportunities that communicate the value of establishing a living trust will help prevent the loss of equity and result in money and time being allocated instead of to the probate process. AB 717 will facilitate the development of state information resources that explain the value and establishment of living trusts. So that is the amendment to that AB 717. That I liked when I heard, and I mean, you guys can all be that for your clients. You can educate your clients. You can tell them the importance of the revocable living trust and the benefit of having one. It doesn't necessarily need to be in a bill for that to happen, but it's in a bill, and that's what CAR is supporting it at this point. So that's all that I'm going to say about that. Any questions? Hi.
Can you talk about the difference between a living trust and a family trust?
Yes, so the difference between a living trust and a family trust, they're the same thing. People have different names for the same thing. A revocable living trust, a living trust, a family trust, they're all the same thing. Basically, it just means that the owners of the trust, which are the trustors, create this trust, and it is for the benefit of the beneficiaries. And the beneficiaries are named in the trust, and that trust is what outlines how things get distributed. If you don't have a living trust, then it'll go by law. It'll go by heirs at law. And heirs at law are usually, it'll be spouses first. So regardless, let's say it's a second marriage, and you know, you have 4 children from a previous marriage, but you're married. So usually heirs at law are spouses first, children second, parents third, siblings fourth, nieces and nephews fifth. So that's kind of heirs at law explained in a really nutshell. There's a lot more complexities to it, but that's what the court would do through the probate process. They determine who the heirs at law are. Well, with a living trust, it will always go to who your wishes are and who you want to inherit the property. So, okay, next. Okay, so LLCs versus corporations. So a lot of you in this room may or may not be incorporated. I really hope that you're all incorporated, because there are a lot of tax benefits for those of you that are selling property to being incorporated. It's a huge benefit at the end of the year on taxes. It's worth it. So definitely please talk to your CPA. If you would like to get incorporated, contact us. We're not that expensive. We charge $950 and we can get the corporation set up for you very quickly. But so LLC versus corporation, which is a better fit for you? So depending on your company income, then corporation or LLC, corporations are usually the best tax benefit. So if you are buying real estate and you're holding property in real estate, then an LLC is fine, because it's just a holding, it's just an LLC, it's a holding company. But if you are doing business and are making money and want to be able to write off the money that you're making, then a corporation is the way to go. because you get the greatest tax benefits. And this is not information from me, this is an information from our CPA in our office. Every time we set up an LLC for someone who has a business, he'll call me and say, change it, convert it to a corporation. So just set up a corporation, you're better off. A lot of people don't like setting up corporations because they go online and they research, and that's the problem with the online research, is that you can read whatever you're looking for. There's 100 answers to the same question, and it's hard to know what you're reading. That's another reason why it's good to have someone that is knowledgeable. We're not attorneys, we're not representing, but we've 25 years of experience in dealing with documents. You learn a few things, just like you guys have learned so much in your years of experience as agents. So a corporation is a better way to go. And then an S Corp is what an S Corp means. A lot of people don't know what an S Corp means. An S Corp means a small business corporation. So basically it's an extra form that we will send to the IRS after the corporation is set up, and it lets them know that they're going to treat that corporation like an LLC. So you're going to have all the simplicity of having an LLC. You get a K-1 at the end of the year. It goes to your personal tax returns, but it's still taxed as a corporation, which is why it's great. And then, like I said before, any realtors who are selling property should have a corporation. We've had realtors call us after they've sold the property to set up a corporation, and then they've gone to their brokerage and asked if they can switch it, take their social security number off and put their tax ID number on for the commission, and the answer is no. So don't wait until it's done and closed. Do it as soon as you open escrow. If you don't want to do it too soon because you don't want to spend the money and you want to wait, do it while you're in escrow, because we can get it done while it's in escrow, and we can get it done, get a tax ID, get it to escrow so that everything is done before it closes. And then I'm gonna just quickly look. And then realtors, you should all just check with your CPAs to see what you should do and how you should structure it, because they know your personal financial situation. So they'll help you with all of that. We do the initial filing, we'll get it set up, but your CPAs are the ones that are gonna write everything off for you. So they're gonna teach you what to do to write things off. And then every house you help your clients buy should be placed in an LLC or a living trust. Like this is very important information for you guys, because if your clients are buying property and they're buying them as an investment, then they should put them in an LLC, because they're going to get the best tax breaks. If they're buying it as a personal residence, then they can put it in a living trust for themselves. But by guiding them and helping them, what you're doing is you're building rapport with your clients. So they are going to like that you're helping them and guiding them, and then that is going to be, better for you in the long run. They'll appreciate, your clients will appreciate you and giving them the guidance and help you build trust, rapport, and it just shows that you care. That's all. And then just a little, I started with about Laguna Legal. Just wanted to give you guys a little bit of information about Laguna Legal. One of the things that we do offer at Laguna Legal is we have monthly memberships. So we charge $100 a month, and the $100 a month enables you to get unlimited consultations, unlimited, $500 credit during every year, and that grows. We also, if you have a corporation or an LLC, we'll do the annual filings for the corporation or LLC, and then we're also listed as a monthly member, like as your agent for service of process on your corporation or LLC. So that's what the monthly membership is. How we have a lot of agents who use the monthly membership as a tool to help their clients. So that's what I wanted to talk to you guys about, because if you guys are monthly members of Laguna Legal, then you can bring your clients to the unlimited consultations will extend to your clients. We can't extend it to your clients if they come without you, because that would be just crazy for us. So you can't just say you can always say call Laguna Legal, they'll call us, we'll schedule them for a consultation. But if you schedule a consultation with them, come in together or do a phone call with them on the phone as their as their agent, then it goes a long way for goodwill. It goes a long way for building trust with your clients. So we have a lot of very successful realtors who have signed up for that monthly membership for that reason. It usually starts with us helping them set up their corporation, and then from there they're like, oh, we'll try this. It's a 6-month minimum that we have you commit to when you sign up, but honestly, we have members that have been members for 15 years. So there are members that keep the membership because there's a benefit to it for them and their clients. And eventually, after you're a member for a while, you never have to pay for any legal documents because the credits add up. So it's all part of that membership. Any questions about that?
Gosh, I missed the most important part.
Oh, hi, Car.
So, hi. I just, regarding the attorneys that are there, well, how does that open us up as agents to lawsuits and say, oh, your attorney didn't give me proper advice or this or that or the other?
Well, I think that's why it shouldn't be you guys giving the information. That's why, because if you bring them into Laguna, like for Laguna Legal or to an attorney or whoever you have a relationship with, I know you guys all have your own relationships, but by doing that with your clients, we have them sign a disclaimer form. They know we're not attorneys, we're not giving them legal advice. And then all you're doing is you're just referring them to a legal document service that might be able to help them and answer their questions. So it's by giving, when you're yes, okay. There is a document that will help you. Yeah, and help us as well. Okay. So just a quick little picture of the Laguna Legal team. So those of you who've been to our office know this, but those of you who don't, we have 8 motorcycles in our office. So that's our decor. And my husband Roland is in the back. He is the one on the motorcycle. That's my daughter Layla on the right, and then my cousin Atefe, and then Sienna and Janet Rico. So you guys may be familiar with Sienna. She's been going to the marketing meetings, and you've seen her at the marketing meetings. We are expanding. We are looking to hire someone. I know you all know somebody. If you know someone that's in that has a title or escrow background, that's familiar with these types of real estate documents, please send them our way because we really need some more help at the office. We are busy. So, and then our clients, our breakdown of our clients, we usually do about 25% of our business is real estate documents. 25% of our business is living trust and estate planning. 25% is probate, divorce, and other court filings. Under other court filings, there's miscellaneous court filings. There's so much that we do. I can't get into all of it, but we do it all. And then monthly members and LLC and corporation clients are another 25% of our business. So just wanted to kind of give you an idea of what we do. And we have clients worldwide that we service. We have clients in China, we have clients in Iran, we have clients all over the place that are calling us and asking us, they have to go, when we're doing deeds for clients that are worldwide, they have to go to the US Embassy in that country and get the documents notarized and recorded. Get notarized at the US Embassy and then FedEx or DHL the documents to us so that we can get them recorded for them. But we do service clients all over. We do mechanics liens, but it's kind of tricky because we'll do the initial recording, but they have to file a lawsuit within 90 days of doing it. But yes, we do. And we can help them with filing as well, especially if it's a small claims, then we definitely can help. And we visit our website, lagunalegalhelp.com. We have a lot of information. We touch a lot more on all the things that we do on our website. And please follow us on social media. Social media is great. I would really love it if you all take out your phones and do that now. We're on Facebook, Instagram, LinkedIn, and that's about it.
Awesome.
Yeah.
Thank you so much, Ali.